Jonathan Pollard, Fort Lauderdale. Today I'm going to talk about a very specific type of employment claim, which is workplace sexual harassment and even outright sexual assault. I think over the past several years, it's become readily apparent to most folks in society, if they weren't already aware of it before, they're aware of it now, that sexual harassment is prevalent in the American workplace, and even sexual assault is relatively common. So I'm going to unpack some of this, and I'm going to get into legal strategy and how I believe these claims should best be pursued. First and foremost, just to give you an example, right? I have been involved in a number of cases that dealt with sexual harassment or even outright sexual assault in the workplace. And just to give you the fact pattern from sort of one of the more egregious cases I was involved in, there was a lady who was a sales representative. She was very good at her job. She had won sort of numerous awards from the company for sales performance, for meeting very aggressive targets. She went to company-wide conferences. She was asked to speak at these conferences. She was asked to train other sales folks. She was repeatedly praised for her performance. Well, what happens? She gets a new regional manager, a regional sales director. And the regional sales director starts hitting on her, starts propositioning her. There's a lot of social functions that are involved in her line of work. There are trade shows, there's conferences, folks are always going out to happy hours, having drinks, etc. And so what happens? Her regional director not only is harassing her and propositioning her, her regional director starts sexually assaulting her. People say, well, sexually assaulting, what do you mean by that? Well, the reality is if somebody is grabbing you, if somebody is touching you in a manner that's uninvited and that's non-consensual, that can rise to the level of sexual assault. And in fact, in many instances, it certainly does. If you're a regional director who's coming up from behind somebody, massaging their shoulders, putting their hands around their waist, that's sexual assault in my book. For instance, it went even further than that in terms of unwanted touching, groping, physical contact, in addition to just constant propositioning, constant lewd comments. So what do we have here? We don't just have sexual discrimination, we also have sexual assault. Now the discrimination piece kicks in because this person was ultimately, as a result of not going along with these advances, she was given more and more aggressive targets. And that gets into a subsidiary topic, which we can talk about at some point in the future, where I see companies in the sales context that have a nefarious reason for wanting to run somebody out, whether it's discrimination, whether it's whistleblower retaliation, or what have you. I've seen situations where the company just singles this person out, targets them, and gives them the most insanely aggressive sales quotas possible. So basically, while everybody else is sort of operating on a level playing field, they give this person insane quotas that nobody could meet. And then at the end of the day, they say, hey, well, look, I'm sorry, Sally, you didn't meet your quota, so you're out the door and it's for performance. But in reality, it's not for performance. It's because she didn't sleep with her new regional director. So I've seen, and in that case, some people look at it and they say, okay, sexual harassment, gender discrimination, Title VII or the state law counterpart. That's fine at the demand letter stage to raise the sexual harassment, the discrimination, the Title VII, etc. But the reality is companies are not really afraid of the damages that flow from a discrimination case. Because in the discrimination context, your damages are relatively limited. Let's not sort of BS and be politically correct here. Okay, let's just be real talk. Somebody was making $125,000 a year and they lost their job and they sued for discrimination. What are they going to get? Well, maybe they get 6 months back pay, maybe they get 6 months front pay, something to compensate them for interest, fringe benefits, etc. But it really is limited by what the person was earning, and it's further limited by mitigation of their damages. In the employment law context, Title VII context, you have a duty to mitigate your damages, meaning you have a duty to go get another job. So if you take somebody who is incredibly talented, incredibly competent, they have great work history, they are very successful, they have tremendous performance reviews, and then they exit a company on circumstances like this, that person's a hustler. That person is a gamer. They are going to go back out there and they're going to get another job in a relatively short period of time. And what that does is that limits their damages. And from a sort of societal public policy standpoint, I understand that, because folks should not be able to say, okay, I was discriminated against and I lost my job, and now I'm just not going to go get another one and try to rack up these big damages. But by the same token, if somebody's fired wrongfully in an illegal discriminatory fashion from a job that they worked out for several years, where they did good work, and they had a lot of colleagues who they got along with, and they took a lot of pride in their work, and it's disruptive to their life, and you're really not going to get much in the way of damages for that. Even under some state laws that govern Title VII type claims, so state employment law regimes, state discrimination law regimes, you're really limited when it comes to damages that go beyond wages. You can get some type of compensatory, emotional distress, sometimes punitive damages, depending on what the state is, but it's generally fairly limited. You're not looking at much more than a couple $100,000. So in sort of your home run employment discrimination case, you're looking at, at most $400,000 or $500,000. That's a huge employment discrimination award or verdict. So when it comes to the context of sexual harassment and discrimination based on sort of quid pro quo discrimination, improper contact, improper touching, etc., lewd remarks, propositioning, when things go in that direction, you really have to ask yourself whether or not there is some type of assault claim. And the company is not going to necessarily be vicariously liable for the acts of a manager or a director. But here's the real wrinkle, okay? I have seen many instances in which that person, the regional director, and call him Frank, okay? Frank is not a one-time offender, right? Frank has had multiple complaints against him in the past for doing the exact same thing. There have been 2 or 3 other female sales representatives in this district or in his prior district who have gone to the company or have gone to HR or have called the hotline or sent an email and said, Frank is making me feel very uncomfortable. He's saying, sexually explicit things to me. He's propositioning me. He's pressuring me to sleep with him. He's touching me inappropriately. At that point, you are now in way bigger and better territory from a legal damages standpoint than you were in under just a discrimination regime. Because now, it's not just an employment case. Now, it's an assault and battery case. So if Frank is sexually harassing and improperly touching his female subordinates at work, and he has been reported by some of those women to the company in the past, the company is now on notice, and the company is retaining him while he is doing this. The company can now be held liable under a theory of negligent supervision and negligent retention. And where's this go from a damages standpoint? Well, this opens up the door for huge damages on the plaintiff's side. I'm litigating a case right now where we are seeking, I believe, $30 million at this point. It's somewhere north of $30 million, our current demand. because cases like this, they don't just open up the door for your wages or your earnings capacity. They open up the door for all sorts of damages in terms of emotional distress, damages based on sort of physical harm, damages based on psychological harm, damages based on depression, damages based on anxiety. All of these sorts of things come into the mix. And not only that, not only do you get those types of damages, not only do you get damages for emotional distress, which anybody who sort of reads the trial lawyer literature and studies sort of like what voice of the defense bar, etc., what they're worried about, they're always worried about non-economic damages, because non-economic damages are the hardest to rein in. Look, if you're thinking about it from a defense standpoint, okay, it's far easier to crunch the numbers and say, okay, this person's damages are, say they were making $125,000, that's their damages. They were out of work for XYZ months. We calculated out. Here's their back pay. Here's their front pay. Done. And then there's these caps over here on non-economic damages, emotional distress punitives. Okay, limited at most, home run ball, you get $500,000. Once you get outside of that discrimination wheelhouse and you're in the assault battery, negligent hiring, negligent supervision, negligence wheelhouse, once you're in that wheelhouse, the damages we're talking about are not limited to economic damages. They're not limited to wages. Sure, like if the person is sexually assaulted at work, has psychological and physical manifestations as a result of this, right, is depressed, is anxious, etc., and that keeps them out of the workforce for an extended period of time, they can absolutely seek to recover those damages as economic damages. But they can also seek all of their non-economic damages in addition to seeking punitive damages. And punitive damages that are not going to be capped under any applicable discrimination type caps. Once you're in the negligence wheelhouse, negligent hiring, negligent supervision, negligent retention, once you're in that wheelhouse over there, you are not governed by employment law related caps on non-economic damages or punitive damages. And the only limit on your punitive damages is going to be a state law punitive damage cap, or preferably the United States Supreme Court ruling in the State Farm case, which caps it at 10 times whatever your compensatory damages are. So if you know somebody who is in this sort of a situation where they are being sexually harassed at work, or God forbid they're being sexually assaulted at work, these folks have rights. These folks have rights, and they have claims that if they are pursued in the most strategically effective and advantageous way, will not only result in a more substantial recovery to the plaintiff and to the victim, but also will result in more severe ramifications to the companies that allow these types of behaviors to persist. So pursuing these cases in the most powerful and strategically advantageous way not only benefits the plaintiff or the victim, it also benefits society at large, because it creates a bigger threat. It creates bigger risk for these companies, which will ultimately, God willing, force them to eventually clean up their act. Jonathan Pollard, have a good day.